problem.
Klockan är just nu strax efter 12.
Mhm.
Jag kanske ska börja prata och säga välkomna. Jag heter Per-Erik Eriksson och representerar Dataföreningen. Och sen har vi också Joakim. Och så jag tänkte du kan få presentera dig själv. Idag har vi dagens inbjudna gäst som är på väg in i mötet.
Och vi hoppas. Det är problemet med distans.
Ja, han är ju inte på plats så man vet aldrig vad som händer med tekniken. Men det brukar funka.
Ja, det...
Och den här typen av aktivitet, vi startade den för ganska länge sedan faktiskt. Jag vet inte om ni känner till det, men jag kan ju berätta det med att vi kan börja med den biten. Vänta ska vi se. Jag ska bara ta upp en webbfönster. dfs.se och så Vastra. Och sen kan jag dela skärm. Har vi den. Dataföreningen, vi är en vid det här laget gammal och ärvördig, men banne med ganska pigg och fortfarande levande förening. Vi startade alltså 1949, vilket jag tycker är ganska häftigt. En bra stund innan jag ens var påtänkt. Men det vi gör idag, ja, om man går till Dataföreningens hemsida på dfs.se så får man information om den saken och där kan man även titta efter hur man blir medlem och sånt här. Men i det här fallet, så det vi håller på med just nu är prata säkerhet med oss. Och det är alltså en aktivitet som går av stapeln första torsdagen i månaden. Klockan 12 till 13. Men inte nog med det, utan det råkar vara så här att vi startade här 4 juni 2020 med en gång i månaden med prata säkerhet med oss. Det var jag den första tiden och sen kom vi väldigt snabbt på att ja, man kanske ska bjuda in lite personer och prata också. Och nu kör vi, vad blir det? Det är ju banne mig 4 år sedan nu. Och vi har kört i princip en gång i månaden. Joakim och GDPR bjöd jag in några gånger i början på 2021. Så efter 3 gånger med GDPR så knoppar vi av och skapar Prata GDPR med oss. Sen blev det Prata Excel med oss som vi startade 8 september. Och nu så har vi sedan den 26 januari 2023 så har vi även jag och Olle E. Johansson kört en aktivitet om de nya EU-lagarna. Så i princip en gång i veckan på torsdagar klockan 12 kör vi alltså prata med oss-aktiviteter. Och eftersom ni är här så vet ni det redan, men det här är alltså för närvarande öppet för alla och kostnadsfritt för alla. Man behöver inte vara medlem i Dataföreningen. Däremot så är ni alltså naturligtvis mycket välkomna att bli det. Det om det. Hur går det med honom?
Han är på ingång, bekräftat.
Bra.
Så jag kan väl presentera mig själv lite kort också. Så
Ja.
jag är då en GDPR-gubbe och jag kan säga att inför det här seminariet så bjöd jag in IMY också för att se om de ville komma och förklara hur det hanterar klagomål och deras inställning till det här med informationsbrev och ja, deras lite lätt, alltså du kan kanske stänga ner skärmdelningen, Per-Erik.
Ja, jag håller på att försöka hitta var bövelen tog vägen. Och där
Okej.
var den.
Ja.
Oh.
Så jag bjöd in dem för att de skulle få prata och förklara liksom hur de tänker kring deras agerande när det gäller klagomålshantering egentligen. Och de har avböjt det. med hänvisning till att de inte har tid att komma och föreläsa. Så jag vet inte om de hade missförstått inbjudan eller vad det kan vara, men så var det i alla fall. Så då tänkte jag att okej, men då kan vi bjuda in en person som har varit ganska liksom frispråkig kring hur IMI hanterar klagomål. Han är en ganska framstående person inom svensk dataskyddsvärlden i Sverige och heter Alexander Hanff. Och nu verkar han vara inne. Så Alexander, do you wanna introduce yourself?
Hi, yes, I'm Alexander Hanff. I run Hanff & Co. AB, which is a consultancy for privacy and data protection work. I worked with the European Commission, European Parliament, EDPB as an advisor, helped develop GDPR, and worked on the upcoming e-privacy regulation. I've been in Sweden for 7 years, and yeah, privacy and data protection are my life.
So, are you shy, or do you want to show your face?
No, for some reason I can't use the camera.
Right.
Apple have made some updates. I've just got back from being away on a trip and literally logged in and got onto the call, so I haven't had a chance to install any updates, unfortunately.
It's a shame. Well, we can all hear you, and today we will be speaking English because Alexander is English, I suppose.
Yes, I am.
So hope you're all fine with that, but the texts from the IMY are all in Swedish, and we'll be sharing some of those. So Alexander, let's start with the broad question. What do you think about the IMY?
I think their enforcement activities are somewhat lacking. Their communication activities are somewhat lacking. And generally, I would say that they're quite obstructive to data subjects when it comes to filing complaints.
Is this a Swedish problem, or is it a pan-European problem?
There are other supervisory authorities which are, I would say, equally as difficult. So if you look at the DPC in Ireland, for example, the ICO in the UK, I've had similar issues with CNIL in France. So yeah, I would say that this is more of a widespread issue, probably down to lack of resources. Which is something that the European Commission should have jumped on by now, as it's their responsibility to ensure that member states appropriately resource their supervisory authorities, and clearly that isn't happening at this point.
Do you think it's that easy, just saying that it's a lack of resources, and then you can forgive?
I don't forgive. I don't forgive. I still think they have a legal obligation to do the duties that they've been assigned, and using legal resources as a political tool. To deny access to justice by data subjects simply because they don't have the resources. I don't think that's a sensible position to come from. It does seem to me that they're trying to weaponize the lack of resources in this situation.
Right. Well, what are the obligations of the Data Protection Authority?
Example, I mean, you want me to go?
And where can we find them? Because if you just look at the GDPR, it's not exactly clear what they have to do. It says they have certain tasks, but the way to actually enforce and deal with these tasks, it's sort of up to the discretion of the Data Protection Authority, at least
to a certain extent.
Text. Okay.
To a certain extent. So we have case law. So we have the obviously Schrems II, paragraph 109. Which states that supervisory authorities must investigate all cases with all due diligence. This was reinforced in the Schufa case in relation to a competition case, which was before the CJEU as well, which referred to the Schrems II case. So there are certainly binding case law which requires supervisory authorities to take respective measures with regards to investigating all cases.
We can bring up the Schufa case.
Yep.
Yeah. So I think it's here, 56
while you're
and
bringing
57.
that information up, I guess now might be a good time to butt in and say that if you have any questions or comments, feel free to put them in the chat or
raise your hand.
Yeah.
Yeah, and you will get to speak.
You can't see it, but I have two screens in front of me. on one screen is the Zoom window, and on the other one is the chat box. So I'm monitoring any questions from you.
So here, sorry, go on.
Yeah, so if you look at 56 and 57 of the Schufa case, it kind of looks like they have a logic to the order of processing a complaint. So here it says that they are required to handle complaints, right?
Yeah.
In accordance with Article 77(1), and
yep.
that we are entitled to lodge complaints, right? And the supervisory authority must deal with a complaint with all due diligence, judgment, blah 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 blah.
Yeah.
And referencing the Schrems II case, as you mentioned, right? And
if you look at paragraph 109 in Schrems II, it's a little more specific as well. So here it just says they must deal with such a complaint with all due diligence. In the Schrems II case, it states specifically they must investigate all complaints with all due diligence, not simply deal with all complaints.
Here it says it's required to examine the nature of that complaint as necessary.
Yeah.
They use a very similar rhetoric in both of these cases. So I would say that they're more or less this. I mean, since they're referencing back to this one, you have to read them in conjecture or in conjunction with each other. One cannot exist without the other.
Yeah. And then we also have a recent Advocate General opinion. I forget the case number. It's just a couple of weeks old. States that in the event of an investigation where there have been violations discovered, then the supervisory authority must enforce the law effectively as well.
And that's what the second article says here. That in order they must react appropriately in order to remedy the shortcoming found, right?
Yeah.
To essentially, they need to use their corrective measures if they have found a breach.
Yes, exactly. And the situation we have with IMI here in Sweden is they're sending out letters to data controllers, and in the letter they explicitly state that they're not being investigated, that a complaint hasn't been investigated, that the letter is not in any way any form of decision, and they even state that they're not even confirming that the data controller is the subject of the complaint. So it's very clear from the letters, and obviously my interpretation is based on a machine translation, but I presume you'll confirm the same from the Swedish version.
I can absolutely confirm the same. And we can all read here, right? It says that they have. This is a case where I complained as a data subject, and this is the conclusion of that complaint.
And I've made a couple of complaints as well, and I've had the same response.
And as you can see, this is fairly new. So this is from this year. And here we say, well, it clearly says here that they have not made a, they haven't taken a stance regarding the contents of the complaint, and they have not made a decision whether the person that is being complained to is the data controller for the data processing in question, or if there has been a breach of the GDPR. So exactly. So the question here is, okay, so have they, investigated with all due diligence?
And I would say it's fairly clear from the wording of the letters they're sending out that they haven't. I mean, I would say it's quite explicitly clear that they haven't, right? Because they explicitly state that they haven't done so. So it's a difficult one to argue, although they are arguing in front, because I've appealed. So I have a case in front of the court in Stockholm currently.
Do you want to share the letter or like the response from the IMY?
I'd have to. The response from IMY, I'd have to dig it out because it's in the court system. I don't have it on my local system, so I'd have to log into the court system and grab it from there. But they basically arguing that they feel that these letters are successful, that they're meeting their obligations under the GDPR, and that as a result of these letters, data controllers are behaving more appropriately. So I sent some freedom of information requests to IMI as off the back of that to find out how many cases they've had since the 1st of January 2022 to May 2024, where they've sent these letters out. It turns out that in 39% of cases, they've sent these letters out. So, and that's for over 1,000 complaints that have been filed during that time period. So 39% of the cases which have been sent out, cases that people are complaining about, have had this letter sent out, which I would argue is not indicating that they're doing their job appropriately. So I also asked how many times have they had to send these letters repeatedly to the same data controller. And conveniently, since 2023, they've now stopped putting the identity of the data controller in their case management system, so they can no longer provide this information. It's my belief that they've done this deliberately to complicate freedom of information requests, because under the freedom of information law, if the system is not already set up to report in this way, then they can decline the request. So because it requires them to do extra work to organize the data in a way which could be
you don't need to create new
exactly
documentation to fulfill an information request. That's
exactly true. So the information I was able to obtain up until mid 2023, when they implemented this new policy, shows clearly that there are a number of data controllers who have had repeat letters over a period of time, which would seem to indicate that these letters are making no difference. And if you look at the cases which I've had to deal with, which would be Region Uppsala and Boca Direct, my two recent ones, and we're still seeing the same violations occurring on both controllers. On behalf of both controllers. So clearly these letters are not having the impact that IMI are claiming they're having, and their own freedom of information request shows that clearly the vast majority, 39% of complaints which are made, are having these letters sent out. And we have to keep in mind that this isn't necessarily the end of the letters going out for these complaints. This is just the ones they've sent out so far. So there's no indication from IMI whether or not the other 61% of cases have been handled in any different way, or if they're still in the queue.
Well, I mean, when I looked at, if you just look at their statistics from that they publish themselves, they do claim that information letters is the main way to close complaints. So I would guess that it's much more prevalent than just 33%.
Yeah, well, 39%. Yeah, I would expect it to be higher as well.
Yeah.
But of course, it's going to be very difficult for us to obtain this data because, as I said, now they've stopped putting the controller's identity within the case management system, so we can no longer search to find out how many letters have been sent to a controller in order to establish whether or not those letters are effective.
Right. This is IMY's response in my case, also coincidentally to Region Uppsala. So clearly we have a situation where the region in Uppsala do get, several information letters regarding their processing, right? So, and here it says, that they are referencing a EDPDB guideline that used to be internal, and they are referencing court cases, Swedish court cases, where they are stated to have a certain amount of liberty and how to deal with a complaint, right?
I would say with the EDPB guidance, they've been extremely selective in their quoting from that guidance, because actually in that guidance, it also states that they have to take effective remedies as opposed to just do the investigation. So in the event that a violation is discovered, then the remedy must be effective in encouraging the data controller not to commit the same offense.
So are you accusing lawyers of cherry picking what they want to reference?
Absolutely.
My God, who would have thought it? So well, I mean, sure, that's kind of what we do to an extent, but if you're cherry picking to the extent that they're doing now to really, obfuscate what the actual guideline states, I think we have a problem. We're not really dealing with a honest actor.
And keep in mind as well, in your situation here, and certainly in one of my cases against Region Uppsala, we're talking about special category data here, health data. I had two
not in my
complaints
particular
against
case, to be
in
fair,
my case it was.
but,
In my case it was. So the first case was in relation to mental health counselling. I was involved in a road traffic accident back in 2 years ago, where sadly somebody died in my arms whilst we were trying to revive them. So I sought counselling for that, and it was recommended or suggested because of COVID that counselling be conducted over Skype. This was during the period of time where we just had the Schrems II judgment. So clearly using Skype would not have been appropriate, and this was happening to over 10,000 people per month in the region Uppsala region. So, you know, for them to simply send an information letter on such a serious violation in relation to mental health data, I found to be completely inappropriate. And my second complaint against Region Uppsala is in relation to some heart surgery I had to have after a bad reaction to COVID vaccine, which they then shared, despite the fact that I'd stated I didn't want any of my medical data shared. They then shared with Gothenburg University, who reached out to me because they wanted me to be involved in some research project they were working on in relation to cardiac health. So when investigating that situation, it turns out that in order to take part in that study, you have to go to their website, which has a bunch of trackers from Facebook and Google and various other entities that we wouldn't want access to our health data. And again, it may have decided that the appropriate action is to send an information letter. So, I mean, these information letters are clearly a joke, I think, is the only way we can explain them at this point.
Well, I mean, the thing with the corrective measures, right, is that they need to be corrective.
Exactly.
Right. And the question is if you can really conclude an investigation by just informing someone that that someone's complained about them. I mean, I don't think that you're not investigating whether there's an actual breach of the GDPR or not. If you're doing that, you're just sort of, I mean, it's the equivalent of a rejection of the.
But the crazy thing there is they're not even doing that. They say in the first paragraph of the letter that they're not even guaranteeing that they are the data controller that's been complained about. Right?
Exactly.
So they're not even going as far as that.
Right. So it's really, if I mean there's no investigation being done, and the funny thing is, right, that I mean the courts they are referencing, you know, the courts here in this particular case and this particular case, which I happen to have here, and the courts do claim that that the IMY has, you know, discretion to decide on how to process complaints, and that this falls within their jurisdiction and how they're supposed to process complaints based on, for example, right, the Swedish proposition to the GDPR, which is, I mean, I don't know if you're familiar with how like the Swedish legal system works, and what we call it, like a teleological interpretation of the law. But generally, you know, that applies to Swedish law, right?
Yeah.
When you're using a proposition to investigate the intent or like to determine the intent of the legislation, right?
Yep.
But the GDPR is what kind of law?
EU law.
Right. So the question is, can a Swedish proposition really be used to investigate the intent of the law and determine, you know, the teleological reasoning behind, you know, the purpose of?
I think the answer to that is answered in other case law, not necessarily related to GDPR cases, but case law in general from the Court of Justice, where we've seen a number of cases which have challenged member state interpretation from the perspective of their own sovereign national laws. And there's countless examples of that within CJEU case law.
Right, because the point with the GDPR is that it's a harmonization legislation.
Yep.
So if each country gets like discretion to interpret the law independently, then there's no harmonization.
Exactly. And the whole point of GDPR being a regulation, in fact, one of the main purposes GDPR was created in the first place was to take the data protection law from a directive into a regulation to remove exactly this issue, to remove the issue of forum shopping, which was happening under the previous directive, because directives can be interpreted in different ways based on the member state. Whereas a regulation does not have that flexibility. It's supposed to be applied exactly the same in all member states, with the exception of the derogations within the text. This is not one of the derogations within the text.
Absolutely not. So I'm happy that we're in agreement there, and I find it I find it fascinating that the courts do, because there's another, generalized, like a general rule, and when applying. When the courts should know the law, right? That is one of the basic principles of the courts, and this kind of shows to me that they might know the Swedish one, but they get confused when we enter the international arena.
Yes.
Yeah. So I'm kind of skeptical to these kind of statements and how they're interpreting the rules. And here we have something this is an interesting interpretation of the Schufa case. They are basically saying that the courts, they are, even if the IMY has to process all complaints with due diligence and all of that stuff, and when it comes to corrective measures, they need to they have like a certain discretion in which corrective measure to use. What they're saying here is that the courts can try, to an extent, if they are within their discretion to apply a corrective measure, right? And and somehow this court case ended up being about trying the information letter as an appropriate measure regarding the discretion of corrective measures. Which is,
I find it hard to see how it could be considered corrective measure when they state explicitly in the letter that they may not even be the data controller that they're interested in. Right?
Well, I mean, the funny thing is, right? They sort of say that, oh well, it's mainly like they claim that it's mainly regarding corrective measures, but they still consider that this is within the discretion of the data protection authority. So the funny thing is right here that the list of corrective measures do not include an information letter.
No.
Right? That is an investigative measure. Like you can start an investigation by telling someone, hey, that someone's complained about you. What do you have to say for yourself?
Yep.
Sort of. That's how the logic of the law is written. But somehow the courts seem to have muddled the waters here, and they confused the two things. So, I mean, what can we do about this when the courts are clearly, misinterpreting?
Well, my case is still before the court, so it's I would think it's due to conclude this month, would be my guess based on the timelines. And I'm not confident that I'll seek the result or obtain the result I'm seeking. So at that point, I will then refer to the European Commission infringement procedures and try and take action against Sweden as a member state for not appropriately implementing the GDPR.
Can you do that after just the first instance? Don't you need to?
I mean, Anybody, any
exhaust.
individual, no, any individual can file a complaint for infringement under any circumstances. You don't even have to file a complaint within the member state first. If you believe that member state is in breach of their obligations under the TFEU, then you have a legal argument to present to the European Commission, and then it's up to the Commission to determine whether or not they're going to issue infringement proceedings. I did this in the UK, for example, back in 2010 in relation to their surveillance law, and the Commission took enforcement procedures against the UK. Took them to the Court of Justice, and the UK, as a result, were forced to change their surveillance law. And this was without me having made a complaint to the UK government in relation to their existing surveillance law. So there's certainly situations where, or certainly other options open. The problem is the European Commission are incredibly lax when it comes to their own responsibilities. As we know, they've only recently started to reevaluate the adequacy decisions, for example. Which should have been done a couple of years ago already, because it's supposed to be done every 4 years. So there's been a large lapse in the responsibilities of the Commission anyway, as well as with regards to appropriate resourcing. But I'll push, and we have a number of cases now in the Swedish courts to support such an argument anyway. So we have the evidence there to show that clearly these measures that IMI are taking are not appropriate, and that they're not corrective measures, as you said. The information letters as part of the investigation process, fine. But as a corrective measure, no, they're not a corrective measure. And they're never going to be a corrective measure if there's no determination that anything has actually occurred in the first place, because there's no investigation, right?
Well, I mean, you're skipping the first step, right?
Yeah.
In the logic. So I agree. Yeah, we're not getting anywhere with these. So, but I mean, like, have you been in touch with the IMY? Have you seen how they talk about these information letters? So what are they? How are they motivating using these?
I mean, they're very closed off at the moment. I've done a lot of work with IMI over the years at Nordic Privacy Arena. So I'm a regular moderator at Nordic Privacy Arena, which is the big privacy event here in Stockholm.
Well, we met there last year.
Yeah. And IMI tend to have representatives there on a number of panels every year, and I've been moderating them. So I'm familiar with what they're doing, and I'm familiar with the staff who are there. But this is external, right? This is how they're portraying themselves at the event, which is not necessarily reflective of what happens on the internal processes. And I haven't been able to reach out. In fact, it's almost impossible to reach out to them as a non-Swedish speaking person, because all of their procedures are in Swedish. And there have been a number of occasions where they tried to force me to use their online form to submit complaints, for example, which is completely unusable for me. So I sent them a letter of complaint via email, and they've now accepted that they will accept those complaints. But the result is they're not doing any investigations anyway. So what's the point in filing complaints, right? It just takes a huge amount of time, and there's no benefit to the data subjects. It's certainly not enforcing or protecting their fundamental rights. And that's what's so annoying, because these are fundamental human rights. We're not talking about simple miscarriages of justice here. We're talking about Article 7 and Article 8 rights under the Charter. So I would argue that IMI are actually diminishing those rights by refusing to conduct the investigations appropriately to enforce them.
Because I don't know if you saw that, but the IMY they have written a blog post about why and how they motivate using information letters.
They're very good at writing blog posts.
Right, yeah. So I can share that. They have something. It's ironically by the same person who approved the Albin Brunskog. He's some kind of team leader or avdelingschef or whatever. He's a management in IMY. We actually went to school together, me and him. Yeah, so he's a lawyer from
Did he put as much due diligence into his schoolwork as he does into his IMI work?
That's a good question. I mean, I didn't. I investigate them much more thoroughly than I did my homework. Let's put it like that. Well, even doing the law program. So, but the funny thing is here, that what they claim is that so this is a resource effective way to deal with issues, right? But I mean, you could argue that so is chucking the complaints in the bin as well. That's also resource effective, right? So I don't know if that's a legitimate reason, but they're saying that that it can be effective when it's due to like the data controller not knowing the law. So then you can it can be enough to just contact the controller and inform them about the complaint and the rules in question and information letters, and that it's often appropriate in like minor transgressions.
I think there's a number of issues here. I mean, first
Right.
and foremost, resource effective is not the same as legally effective, right? And their enforcement
Absolutely.
powers are supposed to make them legally effective, not resource effective. So it's a completely redundant argument to start with. Secondly, the data controllers already know that there's a complaint, because the first thing any data subject does when they have a suspicion that a data controller is behaving inappropriately is they file a complaint with the data controller. It's only when that complaint yields no results that they then go to the IMY, or at least that's how I do it, because it's
right. You start by talking to the controller, and then if you're reaching a wall there somehow, then you talk to the DPO if they have a DPO. And
exactly.
then thirdly, you contact the supervisory authority. And
then you file the complaint with the supervisory authority. And actually, in many member states, you're obligated to contact the data controller first before you file a complaint. This isn't something which is there in GDPR, but it is something which is happening at local policy levels in many member states. And keep in mind, I'm on the EDPB Board of Experts, so I do have a strong relationship with the supervisory authorities across the EU generally, and have had for over 15 years now. So I am familiar with how they work and how they operate, and I filed complaints in multiple member states over the years myself as well, and continue to do so. So, I would argue that IMI are not behaving in an appropriate manner. They're not behaving.
So you're saying that this is also this is completely redundant, because the people in question, the people who are being the data controllers, are already in bad faith. So there's no question about there being a misunderstanding or lack of knowledge.
And we also have an expression in English that ignorance of the law is no excuse, right? And this is something
that's not just an expression. That's an actual that's an actual principle within law. That you have to know the law, right?
And there's no excuse
there's also
anyway.
Something in Swedish. The same expression as there's such a Swedish expression as well.
Yeah. And of course, we've had GDPR in place now since 2018. I started working on GDPR in 2011 when the first draft was leaked just prior to Christmas, and worked for 6 years. There's no excuse at this point, 13 years on, that any data controller, especially the size of the data controllers we're talking about here, like Region Uppsala, big major institutions, Boffa Direct, for example,
but it's just a minor transgression.
Agencies. A minor transgression to do this to 10 million people on a regular basis.
So the question is here, okay, so how do they even know it's a minor transgression? That, also it says here engångsföreteelser. That's like something that only happens once,
Yeah, and yet they're not investigating. So how do they even know a transgression has occurred, let alone the status of that transgression, right?
Right. And then it says, if it's not enough, the IMY will conduct an investigation.
So there again, they're admitting that they haven't conducted an investigation at the point where they send these letters.
But the question here then is because you can make the IMY investigate complaints if you just complain again.
Potentially, but it doesn't work that way.
How does it work?
They do the same thing again. They just send out another information letter, as we've seen with
Have you tried it?
I filed multiple complaints against Region Uppsala. Yeah.
For the same issue.
Different issues, but the same data controller.
Right. Because
the same principal breaches. Yeah.
Because I've done I've filed complaints to the IMY and referenced previous complaints and saying that there has been no correction. And what's happened is that the IMY has started investigating the issue. It took a couple of years before I heard anything, but as far as I know, they're still investigating some of the issues. Isn't that enough? Can't we let the IMY just do their thing, and if it doesn't work, we just complain again, and then they'll actually investigate.
Well, I mean, I think that's not a very efficient or economical way of doing things, because it's requiring us to use more of our own personal resources, which is,
Sure.
takes a lot of time.
But it saves on IMY resources.
Yes, but it's not resource effective from the data subject's perspective, right?
I
think
don't
the
know
other
if it
problem
saves resources for the IMY either. I think that's assuming that people only complain once and then forget about it.
Yeah. And I think also when we look at what's going to happen in June, which is where the new upgraded stance for GDPR is going to come into effect, there is then a situation where IMI are actually legally obligated to include the complainant and give the complainant access to the case files moving forward, and be involved in all stages of the communication.
But they're already legally obligated to do that.
But they don't.
Sure, right. Yeah, but they do more this year than last year, thanks to the Supreme Court, or the Swedish Supreme Administrative Courts have concluded that data subjects are party to their own complaints.
And this was in the Schrems complaint, wasn't it? I believe.
I mean, it's.
Well, I'll say Schrems. It was Noib, wasn't it? So
yeah, I think it might have been Noib that pushed that issue. I mean, lots of people have been pushing that issue, but it might have been partly thanks to them. Absolutely.
Yeah.
And it's also something that Sweden has, received criticism from the EU Commission about people not being party to their own complaints and not having rights, really.
Yeah.
Against
I mean, I've been filing complaints with IMY since 2018, which is, would be fairly obvious to anybody who knows me, because this is what I do. I have a particular passion for GDPR and data protection and privacy, and it's been my life's work. So, when I find companies behaving inappropriately, I reach out to them, and if there's no chance of them changing their ways, or if they're not interested in changing their ways, or if they just make excuses, I file the complaints, because they should be held accountable, and the enforcement of that accountability should be the supervisory authority. The question now is, what do we do in Sweden to try and enforce our rights? Because every single person I talk to are in complete concern of the fact that it doesn't matter what they do, the authority is going to do nothing to support them, and the companies will continue, well, not just companies, but obviously public sector organizations as well, are going to continue to breach the law wholesale without consequence. So at what point does enough become enough, when we start to take action against the Swedish government, as I've just already suggested, in filing infringement proceeding complaints with the European Commission, or filing Article 78 complaints under the GDPR against IMI to force an effective remedy, as opposed to just going through this appeal process that we have at the moment? I suspect that the Article 78 complaints would bear better fruit than a standard appeal process, because then it would be tried appropriately in an appropriate court, as opposed to everything being done over email and through remote processes without being in-person cases. So I think that the problem with that is obviously the cost of bringing an Article 78 complaint against a controller, because many people would not be in a situation where they could afford to take a legal action against IMI or even against the data controllers themselves under Article 82, because the cost of that is certainly not going to yield sufficient results with regards to refurbishment of those costs.
78 is effective remedy against the supervisory authority's decision, and Article 82 is reparations from a controller. Yeah.
And the other problem we have there with Article 78 is, as is stated in the IMI letter, they haven't made a decision. So how can you file a complaint under Article 78? Because
they have made a decision. Of course,
they made a decision not to make a decision. Yeah, but
yeah. So it's a rejection, right? So they're rejecting the complaint. That's a decision.
But I suspect that the reason they do this is to try and have an argument against Article 78. On the
that's how it used to work, right? So that they're rejecting the complaint, and they're saying that since we rejected the complaint, this is a status quo situation, so there's no consequence for the data subject, and therefore you have no grounds for appealing the decision. That used to be their rhetoric.
Yeah.
Based on like a really flimsy interpretation of the Swedish administrative law. It doesn't make any sense, because obviously a rejection is something that has legal bearing on the data subject because the rights have been, violated. So, I mean, that's the whole point of the complaints procedure, to, do something about rights violations.
Yeah. I think the other issue I have is, IMI are arguing lack of resources, but they actually receive far fewer complaints than many of the other supervisory authorities based on the information they sent back to me via Freedom of Information. I think it was only 10,000 complaints over the past 2 years. Most supervisory authorities are receiving that every 3 to 6 months, let alone every 2 years. So for them to be taking this position, I find particularly troubling. In fact, let me just find that Freedom of Information response. I'll give you the exact numbers. 1 second. I'll just look it up in my email.
Because I mean, this is a good point. I mean, they claim that they're lacking resources, and that's why they are using information letters. But I mean, still takes 3 months for them to send an information letter.
Yeah.
So
okay, so here we go. So I've got the data here. So the information, so between January 1st, 2022 and April 25th, 2024, they'd received 4,230 complaints, which is incredibly low over the time period that we're looking at. They state that all complaints are investigated to the extent appropriate to the subject matter of the complaint. Complaints according to Article 77 are closed with a decision. But we clearly see from the letters that they're not closed with the decision, because they state in the letters that there's been no decision made. On the third point, I asked them to provide information how many of those.
Well, I mean, the decision to send an information letter is the decision. So I mean,
so out of those 4,230 complaints, they've had 77 appeals. And how many of those complaints resulted in sending a letter to data controller was 1,653. So that's the 39%. So yeah, I mean, there's really nothing that they've sent back which supports their position when we look at it.
Well, I think if you consider that number, a vast amount of the complaints that the IMY gets is probably regarding like publishing grants. And these sites like Mystical and stuff like that, and they've just flat out rejected those.
And apart from last,
this
week they've just stated this week that they're now going to start enforcing against these.
No, they didn't state it. They didn't state that. They state that they have a mandate to investigate.
Okay. Yes.
Yeah.
Will they investigate though?
I don't know, but that's the question. I mean, that's we've talked about these things extensively in this podcast thing, and I think that I mean, it's obvious to me that of course they have a mandate to investigate these issues.
Yes.
I mean, there's no conflict between the GDPR, or there might be a conflict between the GDPR and these publishing grants, but there shouldn't be a conflict between the rights given to data subjects in the GDPR and the rights to publish information online.
Yeah.
So, I mean, like, for example, the rights to access, I do not see that me as a data subject shouldn't be allowed to have access to my personal data and the recipients and stuff like that, just because someone has the right to publish that data. Yep. There's no conflict there, and therefore, obviously, there is a right to investigate how the rights are being handled by the data controller. But apparently, they needed to write the legal opinion about that to clarify it. So, I mean, hopefully, something will happen. I mean, I know that me and Noib have a complaint about Mystical right now, so it might be related to that, because
it's really interesting as well, because I don't know if you recall, back in I think 2018, in the early days of GDPR coming into effect, one of these companies were actually enforced against in Poland for doing the same thing in Poland that they do in Sweden, but we weren't able to bring the same complaints in Sweden because IMI were refusing to investigate on the basis of these media licenses, right? So it's very odd when you think about the consistency mechanism under the GDPR and the fact that GDPR is supposed to harmonize things, where data subjects in Poland have more rights against Swedish violators than data subjects in Sweden.
Well, that's something that's kind of funny as well, because we're talking about complaint procedure, because last year the IMY wrote an opinion regarding the harmonization efforts to harmonize the one-stop shop mechanism and
Yep.
like I'm not a super fan of that proposed legislation, but at least they're stating that people should have rights, and they should be party to complaints and when they're complaining in a different member state. And the IMY response to that was that, well, I mean, Swedish people in Sweden aren't party to their complaints and don't have rights against us according to our personal opinion as a supervisory authority. So why should Germans have? We don't want to make it better for Germans than for Swedes.
Yeah.
Everyone should be equally in the shit,
Yeah, yeah. Race to the bottom, as we say in English.
Yeah, race to the bottom, right? It's better that no one eats cake rather than a few people. So, but they've changed that because of the Swedish case law, which is,
well, they say they change it. Doesn't necessarily mean that they have changed it with regards to their internal processes and the effectiveness of that Swedish case law.
That's right. But what about I mean, because we're talking about lack of resources, but what about, I mean, there are other ways to process complaints. The EDPB has stated that, okay, well, we could have like a sort of a mediating role, these supervisory authorities, and we could have a good faith agreement between data controller and data subject. And isn't that something that you can do and implement pretty easily?
I mean, it should be something they can do and implement easily, but there needs to be will on the behalf of IMY to do that, right? And it just seems to me at the moment that they have no willingness to engage in investigations and appropriate actions unless it happens to be a giant company with external entities involved with it. So, for example, if you look at the Klarna case, Klarna, I would argue, are a global company. It attracts headlines to take action against global companies, as we see with many other supervisory authorities. For example, France taking a lot of action against the big global tech companies and so on and so forth. Whilst all the smaller local companies are basically given free rein to break the law at will and continue to reap the benefits of that. Because let's remember that when these laws are broken, there's a commercial advantage to the companies who are breaking the law. Which then has an impact on competition, an impact on choice and free market economies, etc., etc. So we're not just talking about individuals getting butthurt about having their data processed, in ways which aren't appropriate. This has a much wider impact on not just the Swedish economy and the Swedish business landscape, but also on the European economy and landscape as well.
But I mean, so let's conclude then, like that. What you're saying is that the breaching, not following the law, gives you a market advantage, right?
Yes,
that's what you're saying.
Yes.
So I mean, I don't see that as controversial at all, obviously, right? but the question there is, because it seems to me that based on what I've read from Svensk Näringsliv and the IMY when they were invited to Svensk Näringsliv a couple of years back, talking about this report being drafted by some of the people in our field about what's still wrong with the GDPR. The people from Svensk Näringsliv were like, "Oh, this is such a great report because it undermines the GDPR and it states that there are problems with it." And the IMY, David Törngren, who was invited, and I think it was last year maybe, he didn't really have much to say in the defense of the GDPR in that seminar. I don't know if you read the report, but it basically states that the biggest problem with the GDPR is that people have rights and the companies should be more free to do what they want, and IMY should have a complete discretion in investigating whatever they feel like.
Yeah.
And
I mean, it's when you consider that IMY only exist because of data protection and privacy law, and in this case, I think they deal with freedom of information law as well, don't they? So when you consider that, if it wasn't for the fact that we have rights, they wouldn't exist as a body in the first place. And their duty as a body is to protect those rights. They can do that in varying ways, right? So they can do that through education, they can do that through information notices. But when a right has been violated, they have a duty to enforce the law. And they're certainly not doing that at this point, or at least not in an effective manner, not in a manner which is giving confidence to data subjects that their rights are being protected. I don't feel like my rights are being protected. I doubt anybody in this podcast feels their rights are being protected. And I would suspect that probably most of the people who listen to it would not feel their rights are being protected. So what do we do about that? How can we move forward in a way which holds IMI accountable and brings effective remedy to these issues that are becoming much more prevalent in Sweden as a result of the lack of enforcement? I know as a consultant, when I'm trying to work with companies in Sweden, there's nothing happening. I've worked with some of the biggest companies in Sweden who are violating GDPR and e-privacy directive wholesale without any concern to make any changes. They make it look like they're doing things. So, you know, one of the clients I worked with, a very, very large retail client, they have a vast number of staff working as privacy experts within the organization, but they do nothing but tick boxes. There's no changes to policy. There's no nothing I would consider puts them in compliance with GDPR or e-privacy. And the reason why is because they know there's going to be no enforcement against them. And this has been a huge problem, particularly for legal professionals working in privacy and data protection in Sweden, unless you're representing the data controllers, right? It's been a huge problem for us to be able to exist as companies in Sweden.
But isn't that also a big problem with our field, that most people who work with privacy issues are not actually, you know, pro-privacy?
I would say that is certainly part of the problem, but it's also, you know, on behalf of the organizations who are hiring these people, they're just hiring yes men. They're not hiring people who are interested in making changes. And I know when I started to make noises, certainly in one of the big clients I was working with, I ended up not having my contract renewed rather quickly. I was working with another client who blew the whistle on. My manager blew the whistle on the client, and that didn't end particularly well either. I had to fight even to get paid for that, which was problematic in and of itself. I'm not seeing any willingness from certainly the larger companies in Sweden to meet their obligations. And if we look at the enforcements and we look at the information for freedom of information requests, we can see quite clearly that these organizations are repeat offenders. And I would suspect that the offenses are pretty much identical as well. Although IMI doesn't publish the details of those, but certainly if we were to look at which areas of the GDPR they've been violating, that they would be repeatedly violating them over and over again in multiple complaints. So there's a big problem, and we need to do something about it. And I don't think we have certainly the political situation in Sweden currently to try and do anything. And then
clearly no political interest in these issues.
No, and then of course that would impact the independence of the supervisory authority anyway. So I think the only way moving forward is to try and seek action from the EU themselves under existing procedures such as the infringement procedures.
So you think that we need to sue Sweden to force a culture change in our supervisory authorities?
Sadly, and as somebody who's currently waiting for his citizenship application to be processed, I don't really like saying that on air, but yeah, I mean, sadly, I think that's the situation. I don't think we're going to achieve anything any other way. Certainly, there's no indication from IMY that they're planning to change their processes to make them more effective. And in fact, as we've seen from last year, from mid-2023, they've actually made it even more difficult to measure their own effectiveness because they're not putting the controllers in their case management system. So, yeah.
Well, Alexander, I will tell you that it's been refreshing to talk to you. It's seldom I meet someone who is more cynical than me about the situation we're in. so it's always nice to hear that we have people fighting the good fight, even if I kind of believe in the legal system in Sweden, and I think that even if the first instance courts are, I mean, they are kind of lazy. Sadly, there's a very big assumption that the authorities that are being complained against have done their job appropriately. That's essentially the bias that the administrative courts are working with, right? So
but this is a very cultural thing in Sweden as well, right? In Sweden, you generally don't complain about other people. It's kind of an unwritten rule.
Be that as it may, the thing is that the Supreme Courts in Sweden are more, I would say, honest and intellectually honest when it comes to dealing with these issues. It's just that getting there takes a lot of work, but these
a lot
issues
of work and a lot of resources,
and time,
Okay.
for sure. But it will. They do change things when they make decisions. So hopefully, I still believe in the system to an extent. So I hope that things can change internally before we need to sue the country. But I don't think it's a bad idea.
I support the supervisory authorities. I'm on their advisory board, right? I've worked with them now for over 16 years on multiple issues, and I've collaborated with them for a very, very long time. I absolutely support them and understand the resource issues that they're facing. But that still doesn't excuse the level, and I'm going to use a strong word here, which I probably don't like to use, but it doesn't explain the level of incompetence that we're seeing from IMI. Whether it's incompetence or whether it's just a complete lack of will to do their job, either way, it's not appropriate and it's not serving the public interest in any way whatsoever.
It's negligent, either way. So
yeah,
the reason is irrelevant,
guys.
I would say.
Taking an idea from another program, I guess it's time to start saying that on that bombshell, it's time for us to start ending this meeting. The time is now 1 o'clock.
Absolutely. We are always available for questions, and if you want to get in touch with me, you can find me on LinkedIn or my website, and I'm sure that you don't mind people reaching out to you either, Alexander.
Oh, of course. I'm always happy to talk to people about these issues, always.
So,
Alexander, it's been a pleasure having you here today.
Yeah. And thank you.
It's been my pleasure for being here.
Thank you for joining us on this Thursday that turned out to be a Friday. And well, if we have no further questions or anything like that, then I will say that I hope you all have a good weekend.
Thank you. You too. We have some nice weather to go with it as well. So good job.
For sure. Yeah. Okay.
Thanks, everybody.
Thank you.
Thank you. Bye.
Bye.
Bye-bye.